Welcome back, and I hope you enjoyed your coffee break. Before we proceed to the last panel of the day, panel 3, I will ask my colleagues to post the third motion, the last motion of the day, to the screen. The Slido motion is, the ICC deters crimes effectively, agree or disagree? Yeah, stay tuned. Okay, I think everyone knows how to use Slido. The polls are open, you can vote anytime. On that note, a little levity. I will now introduce panel 3. Our chair, Judge Richard Goldstone, is participating remotely from South Africa. Judge Goldstone was also a founding father, or godfather if you will, of modern international criminal law, serving as the first prosecutor ever of the ICTY and the ICTR. Amongst many other accomplishments, he recently chaired the Independent Expert Review Group established in December 2019 by the ICC-ASP to review the ICC and the Rome Statute system. He will preside over a very accomplished panel, which I call to the bench now, including Judge Kuniko Ozaki, a former ICC judge, Mandiaye Niang, a current deputy prosecutor at the ICC, and Professor Beth Simmons of the University of Pennsylvania in Philadelphia, who has produced some of the best-known research on the deterrent effect of the ICC. Please join us at the bench. And with this, I turn the floor over to Judge Goldstone. Judge Goldstone, you have the floor.
I regret that I cannot be with you in person today in Nuremberg, but I'm very grateful to the Nuremberg Principles Academy for making it possible for me to chair this session remotely. The goals sought to be achieved by international criminal justice may not be fully attainable, but that is no reason for not aspiring to achieve them. Even partial success, and especially for victims, justifies the costs in both financial and human resources. In this panel, we will discuss whether the ICC acts as a deterrence in reality. The topic was considered in considerable detail in an important 2017 publication by this Academy, aptly titled 2 Steps Forward, 1 Step Back, The Deterrent Effects of International Criminal Tribunals. Jennifer Schenzer and Linda Carter were the co-editors of the book. The goals of justice are complex, and for centuries have been discussed and debated by many domestic and international criminal lawyers and philosophers. In her chapter in the book I've just mentioned, Jennifer extracted from the preamble to the Rome Statute the following goals of international justice. I quote the list: retribution, promotion of due process, encouragement of national proceedings under the rubric of positive complementarity, recognition of the interest of the victims, truth-telling and establishment of the historical record, reconciliation, promotion of the ICC and international law generally, promotion of the rule of law generally, maintenance of international peace and security, and individual and general deterrence or prevention. That is a large and impressive list. It is also Sorry for the break, but the direct recording intervened, which I've just switched off. The list I've just read to you is a large and impressive one, but also very daunting. This panel will consider what is meant by deterrence and prevention of international crimes. Some might consider them to be the ultimate goals of the International Criminal Court. With Jennifer Schenzer, I would suggest that they are two among many. The discussion is a nuanced one and not capable of yielding simple or easy responses. At the same time, it is clear that the world, not too long ago, in which war criminals were given impunity and were not held accountable, was more lawless even than the one in which we are now living. And that is difficult to conceive in the times that we are going through right now. It is apposite in this context to refer to the infamous question put by Adolf Hitler to Hermann Goering on the 22nd of August 1939, He was speaking in the context of justifying the brutal measures that he was about to order against the Poles. His question was, who after all speaks today of the annihilation of the Armenians? Since the ad hoc tribunals were established in the middle 1990s, the hybrid tribunals that followed, and most importantly, the International Criminal Court, it has become more difficult in our world to forget the genocides and other atrocities that still continue, unfortunately, to be perpetrated. It has been frequently stated that to establish the deterrent effect of any criminal justice system requires proof of a negative. Would more atrocity crimes have been committed but for the work of the ICC and the other international criminal mechanisms? That is a question that has been all too present in the mind of those who have been involved in supporting mechanisms of international criminal justice. I vividly recall my own sadness and frustration when, within weeks of indicting Karadzic and Mladic with crimes against humanity, those two war criminals perpetrated the infamous genocide against Bosniaks in Srebrenica. They, of course, considered themselves beyond the reach of the ICTY, and they were assisted in coming to that belief by the refusal of the UN troops then in Bosnia to apprehend war criminals indicted by the UN's own court. Both Mladic and Karadzic moved with impunity through UN roadblocks. When I raised this issue with the officers commanding the UN troops, the response that I received was that it was not the work of the military to act as police officers. We do not arrest people, they told me. I was astonished at this response from senior United Nations officials with regard to suspects sought by a United Nations Criminal Tribunal, after all a sub-organ of the Security Council. That approach did not change when at the end of 1995, the UN troops were replaced by NATO troops. I was informed by the then United States Secretary of Defense, William Perry, that the Joint Chiefs of Staff in Washington were not prepared to endanger the lives of their troops by ordering the arrest of the likes of Karadzic and Mladic. Secretary Perry made it clear that it was not his view, but he indicated to me that there was no hope of the political leaders of the United States gainsaying the views of the Joint Chiefs. And the organs of the UN, the Secretary General, the General Assembly, and the Security Council did nothing about it. The failure to arrest those indicted by their own ICTY. The reality is that without the politics, there would be no international criminal justice. And with the politics, dispensing that justice is made difficult, and deterrence and prevention is often blunted. There are examples of successful targeted deterrence. When I was in office as the prosecutor of the ICTY, I was regularly asked by the Croatian foreign minister whether senior Croat officials were being investigated by the tribunal. It was clearly of great concern to him and his government. He was frustrated that I could and would not answer his question, but his concern demonstrated that his government was worried about possible indictments coming from the ICTY. Then, in the middle of 1995, the Croatian army embarked on Operation Storm, its military operation against the Serb forces who had taken over regions of Croatia. With an eye on their ICTY, their military leaders publicly warned their troops against the commission of war crimes. Unfortunately, war crimes were nonetheless committed and prosecuted. But I would suggest that there is a high probability that more and worse crimes might have been committed, but for the active presence of the ICTY. That presence and investigations of the ICTY were much in the minds of the Croatian political and military leaders. I doubt that the same could be said for their Serb counterparts. As we meet today, we are all concerned about the continuing attacks by the Russian military on civilians in the cities of Ukraine. Notwithstanding the enormity of the war crimes being perpetrated, it is difficult to believe that the current ICC investigation and domestic investigations of war crimes committed in Ukraine does not have some deterrent effect on some of the Russian military officials and some of their political leaders. Who knows? Attempts by some Russian military to cover up their crimes certainly points in that direction. and it makes all the more important the establishment of a special court to investigate and prosecute the crimes of aggression that have been committed by the Russian Federation since 2014. To move back again, the pariah status visited by the ICC on Sudanese President Omar al-Bashir undoubtedly led to President Kenyatta and Deputy President Ruto of Kenya voluntarily appearing in The Hague. They realized that as fugitives from justice, they would be unable to effectively act as head or deputy head of state, respectively. Of course, that in no way prevented them from sabotaging the prosecution. The prosecution arose from the political violence that accompanied the 27 national elections in Kenya. In later elections in Kenya, and most recently this year, there has been an absence of that political violence. Again, the role of the ICC as a probability contributed to that. Let me conclude these opening remarks by stressing the importance of analyzing and questioning the deterrent and preventive effects of international criminal justice. As one of the questions raised for this panel indicates, it is important to ascertain what data there is available and what still needs to be sought. So we have a fascinating topic and an excellent panel. I call first on Judge Kuniko Ozaki. As you will have seen from her bio, she has participated in areas of international criminal law in a number of different capacities. She was a judge of the ICC from 2010 to 2019. Judge Ozaki, the floor is yours.
Thank you, Mr. Chair, and I thank the organizer of this important event for inviting me to this panel. Dear colleagues, dear former colleagues, and distinguished participants, the main question posed for this panel is whether deterrence or prevention is the ultimate goal of the ICC. And forgive me, because since I left the court 2 years ago and moved to the academic world, I'm now becoming more and more abstract rather than concrete. So, but maybe my two colleagues here will certainly be more concrete with a lot of evidence and so on and so forth. But anyway, so the main question is whether deterrence or prevention is the ultimate goal of the ICC. To me, the answer is quite simple. Prevention of the core crimes is the most important, if not the only, goal of the ICC. It is quite clear from the preamble of the Roma Statute, which says, determined to put an end to impunity for the perpetrators of these crimes and thus to contribute to the prevention of such crimes. Then, how about deterrence? What is a relationship between deterrence and prevention? In domestic criminal law system, the purpose of criminal justice is said to be multifold, including retribution, incapacitation or rehabilitation of the perpetrators, prevention, and some of them mention social education. As a criminal court, ICC should have all of those effects. However, I would like to emphasize again that the spirit of the Rome Statute, which I believe is to alleviate the human sufferings caused by serious crimes through criminal justice, in order to contribute to the peace, security, and well-being of the mankind, that spirit requires that to prevent the core crimes to happen again should be the priority over other purposes. Prevention may take various forms. Criminologists often distinguish prevention through deterrence, from prevention through formation of trusting law and law-abiding spirit among the population. The prevention through deterrence means to deter the potential criminals from committing crimes using the threat of punishment. In case of core crimes, we have seen many actual or potential perpetrators feel so confident that they are free to do anything, they are above the law and immune from any accusation. Their confidence comes from the fact that they have strong political or military power over the population. They have support from the majority of the population, or they have backings from other powerful countries. ICC here is certainly expected through its investigation, prosecution, and conviction to change the behavior of these leaders and their governments, and thereby reducing the violence against civilians. For the ICC to accomplish this goal, it would be most important to effectively identify and apprehend those who are responsible for the crime and properly prosecute and punish them. It is only through high probability of punishment that the potential perpetrators will seriously start calculating the risk of the commission of the crimes. Prevention through developing trust in law is more subtle, time-consuming, but in my view, more fundamental and effective in the long run. Core crimes are the kind of crimes for which people feel so weak and become desperate and often cynical. People in the extreme situation may lose sense of their norms to live together with their neighbor in the community, as well as their sense of law and justice. People under those situations also easily rely on inhumane measures if they feel them not only permissible, but also necessary in order to survive. Yes, ICC prosecutes those who are most responsible for the core crimes committed, mostly leaders and high-ranking officials. We should not forget, however, and on the bench of the ICC, I never forget that the existence of many direct perpetrators of core crimes, most of them ordinary people, neighbors in the community, who had no hesitation to commit atrocities, or those who supported those leaders committing atrocities. Even if ICC can achieve certain deterrent effects over some of those leaders, others who are more ready to take risk will come back to do the same if we do not change the mindset of the population as a whole. On the other hand, if ICC, through proper criminal procedure, could help those people to foster, recover, or maintain their trust in law, nourish and permit the law-abiding spirit, this will strengthen the community against the temptation of resorting to core crimes or supporting those leaders committing core crimes in order to retaliate and or to defeat the enemies or perceived enemies. This type of prevention is also relevant, of course, from the perspective of post-conflict reconciliation and peace building. And here, ICC alone cannot achieve this goal. ICC here is one of the actors in the wider international efforts to achieve peace, security, rule of law, and well-being of the population, an actor to contribute to those efforts from the perspective of criminal justice. In order for the ICC to obtain this goal, something more than conviction is required. ICC has to show that justice is done in every stage of its proceedings, starting from kicking off of a preliminary investigation. Its procedure has to be fair, unbiased, efficient, and effective. Moreover, what ICC is doing has to be known and realized by the public. Outreach would be a key factor here, so that not only victims but also general public watch justice done. I hasten to add that this does not mean that ICC becoming aid organization or involved in capacity building. We discussed this issue briefly during the previous session. But in my view, ICC is a judicial organization and it should remain so. I am aware of the temptation or aspiration or even needs which many international organizations are exposed to extend its mandate to the fields, and where there may be even more possibility of getting additional resources and support from governments. But I think ICC should be very cautious here. If not, ICC as an impartial court will lose its raison d'etre and will most likely lose confidence by the international society in the long run. ICC is inherently handicapped, however, to fulfill this responsibility, both in the field of deterrence through punishment and in building trust in law. You know, ICC is a small treaty-based organization lacking a state machinery which usually supports national criminal justice system. Deterrence will be effective when most, if not all, criminals who have committed same kind of crimes be convicted equally and effectively. And the same goes for the prevention through fostering sense of rule of law. But you know, here ICC cannot prosecute and punish crimes committed in the territories of the non-state parties. And ICC neither can investigate or prosecute all core crimes committed even on the territories of the state parties for various reasons. But ICC here also has some merit. ICC can ensure and show the proper work of criminal justice, which is fair and impartial trial, fully respecting rights of the suspect and accused as well as the right of the victims. ICC can also more easily rely on and mobilize the cooperation by the international society at large, including the state parties, relevant international and regional organizations, civil society, and other stakeholders. Well, Ukraine, we have seen many supporters of Ukraine's situation. Ukraine might be a bit exceptional, but in most cases, it is easier for the ICC to get this kind of international support rather than situation countries. Complementarity, which we discussed very extensively in the last session, could be another weapon which ICC can utilize in this respect. And by promoting the principle of complementarity, the ICC may be able to put a pressure on the national court to join in the effort without being accused as interfering in domestic matters. In other words, what ICC can do realistically is to concentrate on most grave cases and most responsible criminals, and to achieve its goal of prevention through quality rather than quantity, and through broader international support, utilizing its merit to the most. Of course, I did not mention here one more important function of the ICC process, which is protection of victims. But that I understand this will be dealt with in another panel. But I have to mention here one more very serious challenge ICC is facing, which is the emerging division of values in the post-Cold War era. ICC is established on the assumption that the international society shares certain core values. We are now witnessing, however, that those values are seriously challenged in various fields of international legal order, such as rules on use of force, use or threat of use of weapons of mass destruction, and protection of human rights. In addition to act of aggression in Ukraine, we see a serious schism in recent debate in the UN Human Rights Council. War crime reports from Ukraine committed by the regular army of a permanent member of the Security Council could be another example of such serious schism. I wonder how this will affect our common understanding of humanitarian law, which could be a big setback for the ICC's preventive goals. Yes, nothing is easy for the ICC, and I admit that the most difficult phase is at the beginning of the process, starting with preliminary examination and selection of cases, where prosecution has to carefully navigate between square and caliber death. And with this cue to the next speaker, I'd like to complete. Thank you.
Well, thank you very much indeed, Judge Ozaki, for your contribution, a valuable contribution. Our next panelist is Deputy Prosecutor of the ICC, Mandiaye Niang, who for many years held a series of senior posts in the Prosecution Authority of Senegal. Since March 2022, Mr. Niang has been a Deputy Prosecutor of the ICC. Mr. Niang.
Thank you very much, ladies and gentlemen. I'm grateful to the International Nuremberg Principles Academy for inviting me to participate in this forum on behalf of the ICC Office of the Prosecutor and also on behalf of Prosecutor Karim Khan, who could unfortunately not make it. I am equally honored to join this panel under the stewardship of the renowned Judge Richard Goldstone, and I also greet my fellow panel members, starting to my right, Judge Ozaki and Professor Beth Simmons. I don't know which author say it again, but something I can say that I remember from my very early readings when I was a young boy was this, I don't know whether it was a sociologist or an anthropologist, but one thing he said, and which really resonated at the time with me, was that human beings really, surpassed the other species when they invented the attic. Yes, the attic, in my view, epitomizes indeed our sense of foresight and anticipation, if I can put it that way. And we use that faculty to be freed from hunger in the olden days. So when human being was really strive with hunger, so that invention, that sense of anticipation, so help us to vanquish, to a large extent, hunger. And I think that we can safely say that we can equally use it to avoid punishment resulting from unauthorized behavior. And that's what we do when we stop at a traffic light to avoid a fine. And I think that we can do it to refrain from committing atrocities and avoid thereby the accountability this would certainly attract. Now, whether people always factor this can be debated, of course. But what can be said with certainty is that crime prevention and deterrence have been envisaged by the founding father of the Rome Treaty. And that quote I was about to read was just cited by Judge Ozaki, which of course dispensed me of going through the same citation. But it's right there in the preamble when the mention of prevention is pretty clear. Now, whether the ICC has, through its design or its practice, lived up to this ambition is also a tough question. Since the court inception, of course, mass atrocities have happened and are still happening in almost every continent. Even in Europe, where we thought that the era of war-free zone had been ushered in by this formidable venture of the European Union construction. So now we see what is happening in front of our eyes with this Ukrainian situation, and nobody really knows where it's going to lead us. So what lessons do we draw from this set of affairs? Can we just note that and accept that in as much as a human being can be extremely intelligent, that one could also say that maybe this intelligence is somehow overrated. So, and therefore we should make some room for human stupidity or irrationality, as suggested by the renowned author Yuval Noah Harari in one of his last books. To answer this question, my humble submission is that we should neither rule out the deterrent effect of accountability, nor should we overestimate it. Crimes, and particularly international crimes, they occur with a certain regularity. Short of being able to prevent it, so we should always endeavor to punish their perpetrator. And in my view, in this regard, is that this is the basic function of criminal law. Deterrence is not its primary purpose. If it is aimed at, it is only through that retributive function. But of course, applying the law now in a practical, effective, and consistent way will allow it to serve as an anchor for stability and security, which is much needed in current times. Knowledge of the existing law and its independent and impartial implementation at the international and national level by judicial institutions can be an effective deterrent and put on notice potential violator or halt perpetrator from engaging further in criminal behavior. It is this sentiment that pushes our office forward with a strong commitment to showing agility and capacity to respond in real time to ongoing crimes. Despite what I just said, I think that the deterrent function of ICC exists. This, however, may not translate forthright into mass atrocities eradication all over the world. Without accepting criminality, and particularly to serious crime, as an inherent component in human society, as the founding father of the French sociology put it once, Émile Durkheim, who made that proposition that, of course, crime is almost a normalcy in a society. So I wouldn't go to that extent, but I think that we still have to come to terms with that long-haul battle against the serious crimes, which are fueled by what we call really, what really fuels those serious crimes is religious or ideological extremism, racism, hatred, and greed or grievances, all of which are still very well rooted in modern societies. This said, encouraging signs of the deterrent function of ICC are strongly visible. Sometimes we just do not pay close attention or read them correctly enough to take them for what they really are. The exercise, I confess, is also more difficult in the absence of tangible data. So I see that that question just came in the earlier forum. So that issue of tangible data is very difficult in a sense that, effective prevention does not really leave a trail. It's just seamless. So I would remember here again this American poet. I can't remember exactly the word he put it, but one thing he said that the question he asked himself was, how really can one experience the feel of a road not taken? Because that's what is at the very heart of prevention. Mm-hmm. So, since the advent of the ICC, what I can tell is that the conversation has dramatically changed in many fora. Everybody knows that there exists now an institution that can call to book any leader who misuses his or her powers to indulge in mass atrocities. And personally, at a very, very personal level, as an African, and in my capacity as a former judge of the ad hoc tribunal, and also even as a prosecutor in my own domestic country, and having also traveled a lot throughout Africa, what I can say is that, I have witnessed almost every day this shift in the mindset, not to say in the mindfulness of the existence of the ICC as the body that keeps people in check. And here, what's really interesting in this endeavor is that very often the limitations of the jurisdiction of the ICC are even ignored, willfully or not. Irrespective of the subject matter, the complementarity principle and correlated admissibility requirement. Human rights activists, NGOs, opposition militants, and the like, they call on ICC for somehow an all-out intervention whenever they feel that there is a potential human rights violation, no matter the scale or the gravity. And this, I can tell, does have an impact. Many African leaders are very watchful of ICC. We all remember in 2016 and 17, the outcry of many African leaders threatening to withdraw en masse from the Rome Treaty, partly, but mostly, because they felt that there was a prime soft target of the court. That feeling had already a few years before driven the initiative to fully reinstate in the Malabo Protocol that famous Lotus doctrine on head of state immunity before the African Court of Justice and Human Rights. One, of course, may entertain negative opinions about these moves and initiatives that somewhat can be viewed as going against the normal trend of history, as we somehow in an oblique way discuss in terms of immunity this morning. But what they also tell, those moves, is that there is a great awareness of a full-fledged international criminal justice mechanism, accountability, a mechanism that through different means, including the UN Security Council, may get involved, including in countries that have done their best to shy away from the Rome Treaty. And one example I have time and again referred to was this civil unrest in Burkina Faso in October 2014, when this then President Blaise Compaoré was really challenged in respect of him staying in power. What he did, for my view, was something really worthwhile taking note of. He chose to flee, to leave the country, almost quietly, when he enjoyed a great deal of support within the army. So my own take, my personal take, as I say, it's very difficult to have tangible data, but my own take as an African from that experience was that if Blaise Compaoré has made that choice, so that was also because of the fear in case of bloodshed to appear before the ICC, particularly in view of what just recently happened to his neighbors, Roland Gbagbo. But of course, I think that I will be leaving it at that, from that example, and I thank you very much for your kind attention.
So I will continue the theme of my co-panelists here, that what this panel is challenged to do is to talk about what's not happening. And this is a real tricky proposition to try to support. And I think the case has been made exceptionally well so far, and I'll see if I can carry it forward just a little bit. And by the way, I know there are a lot of skeptics in this audience. Based on the last poll, I was surprised to see so little support for the proposition. And so I hope you haven't voted yet, okay? So I hope you just give us one more crack at trying to make the case that the ICC has done something important and participated in very important ways in this problem of deterring international crimes. So what is deterrence? Deterrence requires shaping perceptions of potential perpetrators so that they see the alternatives to committing an international crime as much more attractive than committing that crime itself. Okay? Now, this can be motivated in a couple of ways, but they need to change their perceptions of what the consequences are going to be. And I would argue we should think about this in a kind of a broad way. On the one hand, I know that this institution and this audience is particularly concerned with prosecutorial consequences. And those are important. These are costs associated with apprehension, hiding, travel restrictions, interacting with legal institutions, and of course, punishment itself. Okay? So that's a whole set of prosecutorial costs in some ways. Those will certainly have the potential to change this perception of consequences. But there's a whole set of other things I really think we need to keep our eye on here as well. And that is that most deterrence, if you read kind of the domestic literature on criminal justice and crime deterrence, there is this concept of social deterrence. And to use the example of stopping for a traffic light, most of the time we don't stop because we fear that we're going to be arrested. I stop because my daughter would say, "Mom, stop, put the brakes on." In other words, it's not a respected and it is understood by those around us to be a consequence, to be something that is not to be tolerated, essentially, okay? Now, I think that this is what we need to keep in mind also when we think about international criminal law. A very important point here is that we need to develop and nurture a sense of solidarity around the principles of international criminal law. That is one thing that the ICC has done, but it is much broader than that. This is something that needs to be broadly supported by the international community. But this idea of kind of social deterrence in some sense is a very important role for the ICC as well, because the ICC plays this important role of being the conscience, the expressed conscience of the international community. And so it is a way to kind of create a focus on what is acceptable and what is not acceptable. So much of what the ICC does is to play this role, frankly. So a legal action is a statement of what the community values, and it needs to be interpreted as such. So that's kind of just the background, the way I kind of think about this issue. The other thing I want to draw a little bit of a distinction about is the difference between deterrence and prevention. I think they are distinct, actually. I think that to deter someone, when we talk about deterrence, we essentially talk about someone who has motives to commit a crime, and we would like to change their calculations so that that doesn't happen. And prevention is a little bit different. You do not want, you don't want people to commit the crime in the first place, essentially. So you make it harder for them to do so. In the domestic context, for example, you might lock doors. You might try to control guns. In the international context, it comes down to the issues of what sorts of things give rise to conflict in the first place that also need to be addressed. There are broader social justice issues. There are broader structural issues that need to be addressed. There are broader issues, related to, the issues of fairness in domestic societies that need to be addressed as well. So that is what, broadly speaking, prevention is about, is preventing conflict in the first place. And I think we need to focus on here what the international criminal law can add to that project. It can't substitute for the project. It has to add something. It adds value, and I will argue actually that it does. So how is international criminal law advancing deterrence? And I would argue that a lot of it is pre-prosecutorial. Because the number one thing that the ICC has really contributed here is to clarify what is an international crime. That needs to be really made crystal clear. Deterrence begins with clarity about what will trigger costs. And so this is one of the crucial things that the ICC does. And this is a process over time to which I think the ICC has, in fact, contributed. It's a slow, hard process. It doesn't just go click like that, and now we all understand exactly, all the people who need to understand don't fully understand what International Criminal Act is. But there are examples that the ICC has played very crucial roles in providing that kind of education. Sexual crimes, for example, as reported, for example, in Martha Minnow's book on managing violence. In the Central African Republic in 2007, she reports an armed rebel group, for example, in this area, requested instruction from NGOs on what is an international crime. We need to understand what it is. And at least some commanders in that instance of this particular rebel group learned that there was such thing as command responsibility for such things. That's not something we should assume everybody knows. That is something we should say is an important project to which the International Criminal Court has contributed. I would say another example would be the problem of child soldiers. So interviews on the ground, for example, by Human Rights Watch found that child protection agencies pointed to the Lubanga case as more effective than their own campaigns to try to protect children on the ground in trying to sort of spread norms about child soldiers. So it's really important to, I think, to give the ICC some credit, some very important credit for these kinds of, teaching project, essentially, in some sense. Now, let me say a few things about complementarity as well, because complementarity has helped raise the risk of the prosecutorial consequences that I spoke about. And so positive complementarity essentially is an effort to make accountability more credible on the ground. And this has been an indirect effect of the ICC statutes and jurisdiction. And we have research and studies in this area, actually. So a really important study by Jeff Dancy with Florencia Montal that was reported in the American Journal of International Law showed that states that experience serious internal conflicts were 4 times more likely to prosecute their own nationals for international crimes and crimes against humanity when they are under the jurisdiction of the ICC than when similar states are not. So that tells us a little bit of something, too, of the kind of context that the International Criminal Court provides. And this was based on very credible evidence from the Transnational Justice Project, which I would also like to underscore. We're actually getting more and better information all the time about the commission of international crimes and the development of complementarity. So I guess the next thing to think about is what the ICC particularly has done in some of its legal actions, again, kind of ratcheting up that risk of prosecutorial deterrence. And the first thing is to think about the role of the sort of preliminary examinations and the effects that those have on international crimes. And so the Commission of International Crimes. So I wrote a paper with Heron Joe where we tried to look into this matter very, very systematically and collected data on all countries of the world, and then tried to look at their pattern where we tried to explain, are there instances in which rebel groups and government forces engage in the intentional killing of civilians. The intentional killing. Now, I understand, we all understand, that that is not the whole gamut of international crimes. It's a big one, though, isn't it? And so we decided to kind of focus on that for the purposes of this study. And in a well-controlled study, we essentially found that credible ICC actions, investigations, arrest warrants, and indictments was one of the most significant correlates that reduced these kinds of civilian deaths. And besides that, it was one of the few international variables that affected both rebel groups' targeting of civilians and government forces targeting of civilians as well. Just a couple of examples real quick is the case of Colombia. And in Colombia, I'll just pop up a little bit of data here so you can sort of have a peek into the sorts of things that we think about when we try to sort of test for deterrence. So Colombia opened an investigation, as you all know. The ICC opened an investigation in Colombia in 2004. And we published research in the Journal of International Criminal Justice that a couple of things. We found evidence, qualitative evidence, that both the government forces and the FARC were actually weighing their risks. We're literally weighing their risks of their possibilities of prosecution when that investigation opened. And then we we spoke in the last panel about some of the institutional changes and toing and froing in the Colombian case. But we investigated behavioral change here. And these behavioral changes essentially show that when you have this point at which the ICC began its investigation, you started getting this tailing off of intentional killing of civilians. Uganda, I'm going to show you something is I think the data are even more compelling. So what we have here, Uganda was the very first situation that the court took up in 2004. And there was evidence that the LRA was attacking civilians. You can see here, what we have here is that the dotted lines are battles, just overall war, okay, just war. Now, the ICC is not designed to stop war. ICC is designed, what we have here are the attacks, the battles, and the solid line is the attacks that killed civilians intentionally, okay? Now, the thing I want you to notice is that before the ICC began its investigations, these were very highly correlated, very highly correlated. So whenever you would get attacks, whenever you would get a battle, a lot of civilians would die, and that's why it says there's a correlation of 0.74 up there. But after the ICC initiates an investigation, essentially what you have is that these curves start to come apart. The battles continue, the intentional aiming at the civilians starts to go down, and you get a lower correlation between simply fighting and aiming at civilians. And I think that's a really kind of an important consequence that we should essentially keep in mind. Now, I want to go to just one case very quickly that a lot of people might code as a failure of some kind, and this is the Kenya case. This was a difficult case, of course, for a number of reasons. The fight over jurisdiction was fierce. The campaign to delegitimate the ICC was in full swing at the time. There was a continent-wide African set of concerns about being the ICC's target, special target, based on imperialism and racism. And so this was a case, of course, with all kinds of interference in the wheels of justice, and it was rife with the violence against witnesses. I mean, this is one of the toughest cases, quite obviously. And they're leading to essentially frustrations that sort of politics had overcome any use that the ICC could be in this case. But let me just ask you whether you think this is proof that deterrence failed. Just put that on the table for a minute, food for thought. Recall, the purpose is not to indict or to prosecute. That's not the purpose of the ICC, nor is it to shut down politics somehow, which can never happen. Instead, the purpose is to be credible enough, to quote the preamble, to deter atrocities that deeply shock the conscience of humanity. And maybe in some ways this happened. To make the calculations that post-election violence is less available, okay? I'm not even sure everybody understood that post-election violence sort of fit in crimes against humanity. There's a learning experience going on here as well. But this past month, there was a really interesting just sort of piece in the newspaper where that I think suggests also just a little bit of, I know my time's out, just a little bit of deterrence on the part of the ICC. And I'm no expert on Kenyan politics, so for what it's worth, and maybe you all can inform me that I've misinterpreted something pretty strongly here. But when a national politician, fresh off of an election loss, in a country that has some experience with the ICC, says that he has been deterred by the ICC out of his own mouth, then I think that, my ears prick up. I don't know about yours. Raila Odinga, whose experience as a mediator in the case of Cote d'Ivoire's post-election violence, remember 10 years earlier, and how many thousands of miles away, right? When he points to that experience as deterring him, 10 years later, thousands of miles away, from sort of stirring up more ethnic mobilization, shall we say, and that the ICC played a role in that, I think we should listen. He said, quote, "When I make certain decisions, I make them with that background information. The then president of Cote d'Ivoire, in this instance, when he was removed from power, found himself at the ICC." Said the veteran, and said this veteran Kenyan politician. Now, just one other quick thing I just want to say. And that was a case of acquittal that deterred him. Now, in my world, that case would have been coded as a failure, when in fact, maybe not. Food for thought. Food for thought. Well, that's all I really wanted to say, is to make that presentation.
Thank you very much indeed, Professor Simmons. I apologize that the break in my connection deprived me of the privilege of introducing you. I apologize for that. Sorry, Jennifer, over to you.
Just for a brief handover again, thank you to our distinguished panelists for those fascinating presentations. And we now have approximately 30 minutes for discussion, which Judge Goldstone will facilitate, and for questions from our audience. And a reminder that the Slido poll is still open, and you can change your votes if you have been convinced,
Good.
one way or the other. The ICC deters crimes effectively, agree or disagree. I give the floor back to Judge Goldstone. Thank you.
Well, thank you very much, Jennifer. I had a number of questions to put to the panel, but I must confess that most of them have been answered by Professor Simmons. But let me ask one question. I think many prosecutors, if not all international prosecutors, have been faced with the argument about peace and justice. We have been accused of inhibiting peace by bringing war criminals to justice. I was wondering whether any member of the panel could throw some light on this issue. It's an important one. And I think in particular, I was wondering whether any of you have any illustrations or examples that you might share with us.
I thought, yeah, he's asking, is there a trade-off between, you're asking, is there a trade-off between peace and justice?
Okay.
Yes?
Can I ask my question?
Maybe we can finish this question. Maybe we could finish this question from the chair, and then we will turn to audience questions in a moment.
Anybody prepared to have a go at?
Well, I've got a thought on
Mr.
that.
Simmons?
Unless you guys, do you want to go first? You want to go first? Well, I guess I would begin with the observation that if you think there is some kind of conflict, if one thinks there's a conflict between justice and peace, let's look at the record between impunity and peace. I think you'll find that impunity has a horrible record when it comes to producing peace as well. So we may be dissatisfied that somehow making the right decision with respect to justice has not sort of led us all down a peaceful path in all instances. But let's remember what the counterfactual is. The counterfactual is impunity. And it is my sense that the record there somewhat speaks for itself as well. So.
Yeah, I think that I have no problem agreeing with that. But of course, sometimes also I look at Article 16 and to see what it encompasses in terms of, for example, suspending prosecution. And my careful thought in that regard is that, there may well be situations where, for example, one may have to weigh some of those competing interests. Not to mention that justice should just be cancelled altogether, but sometimes the situation may well be that, be it under Article 16 or through other mechanism, that giving chance to peace also may be an important factor to take care of.
I quite agree with my previous speakers. I think peace and justice can have conflict in short term, but it's only short term. If you think about it in longer term, there's no peace without justice and no justice without peace. And but for short term effects, there might be some adjustment needed in order just to overcome these emergency issues. That's my understanding of the relationship between peace and justice.
Thank you very much for your responses. I have one other question before handing over to the audience, and that is whether the ICC or any international criminal mechanism can take steps that aren't being taken to further act as a preventive or deterrent. Let me give you one example from my experience. In the case of the Rwanda Tribunal, we went to great lengths to try and make it possible for trials to be broadcast live to the people of Rwanda. We thought that they're very keen football followers, and we thought that football stadiums could be used with huge television screens to broadcast the trials, and that would be meaningful, particularly to victims. It was disappointing, however, that the Rwandan government at that time, for one reason or another, wasn't prepared to agree to it, so it didn't happen. But I was wondering what other imaginative or far-seeing steps can be taken, in particular by the ICC. Outreach is important, but are there any specific areas you think that should be concentrated on?
I think it depends on the situation. I think any measures of outreach should be very, very carefully customized to the society in question, and what kind of people you are targeting for this outreach. So I don't think there is a one answer to that question. Maybe you can too.
Yes, Judge, I think that outreach, in my view, I think that is always a very important factor to be taken into account, because what it means is that what is happening in the courtroom, is it known to people? So meaning that if that aspect is not there, everything we've been talking about is just like put to waste. And it's good that you made reference to Rwanda. Of course, maybe having come to the Rwandan tribunal after you, I think that I was lucky enough to see that shift even in the Rwandan government position. And at the time, as a chief of staff of the registrar, I think that I was part of this wide outreach program, which in fact we roll out throughout Rwanda. And I think that that program was so successful, and Rwanda was even claiming ownership of that process. And I remember that debate went, and if I am not mistaken, Mr. Prosecutor, you even took part at the last batch, which was now the legacy issues, when the talk now was about even the archive. You led a structure, and I think that one of the very strong points Rwanda made was that it wouldn't agree that the archive go anywhere else than in Rwanda. But of course, UN wouldn't take it that way because that was UN property. But we had that compromise to make available all of that through what at the time we called the Umusenzo centers, which was the center of information which we roll out throughout Rwanda. So I think that answers a bit of your question.
Thank you very much. Professor Simmons?
Yeah, I just think that because I come from a sort of broader perspective on deterrence that includes the entire sort of social cohesion around the idea that there's some things that are just really, there are international crimes that need to be clearly understood, that if, to think about outreach in terms of publicizing a court proceeding is too little too late. That this has to be something that begins systematically with clarifying what the law is and why it is this way. And those are the kinds of, to sort of make that message very clear, very early, and that this is the purpose of the ICC, then I think at least makes an audience sort of plausibly willing to, understand a proceeding as being something that is a legitimate proceeding, potentially.
Thank you very much, Professor Simmons. Jennifer, I think this is a good point to hand over to you to deal with questions from the audience and from the online audience.
It would be my pleasure. And before I take questions from Chief Taku and from Judge Ebosuji, I have been asked to remind the participants, the audience behind the gates, that they are in fact open. If you would like to come to the microphone, you may also pose questions. Now, please, for a brief question or comment, Chief Taku.
My question is this. Many multilateral treaties have compliance mechanisms. With the ICC, though, with the domestication of the Rome Statute into the national laws of state parties, so that effective complementarity can occur, what is holding back the state parties of the ICC from holding each other accountable or having a complaint mechanism to ensure that these laws are effectively in the statute books of state parties? Because when the laws are there and the national debate occurs, it is a deterrent effect at some point in time that these people will be held accountable. So you, the panel, Professor Goldstone and others, please, Judge Goldstone and others, what is holding them down? See the sheer number of state parties that have not even managed 20 years on to enact, domesticate the Rome Statute into their national laws, and yet every day they talk about complementarity. If they will allow the complementarity, what are they going to use to prosecute those crimes?
Should we wait for the next question?
Yes, perhaps let's gather one more question and then the panel can respond. Thank you.
Thank you very much. I just one quick, should I say, rectification to the otherwise magnificent speech by Professor Simmons. Since you mentioned the Kenya cases and acquittal, no, there was no acquittal in the Kenyan cases. There was no acquittal in the Kenyan. No, something else. Okay. The point is, because people sort of think that the Ruto. All right. Okay.
He specifically referenced the Cote d'Ivoire case when he said, this is what I, risk, essentially.
When you talked about Raila Odinga, okay, intervention, which was correct in other respects, what I'm saying is that in the Kenya cases, there was no acquittal. So I'm saying this because people think that. But
no, but no, that's not what he said either.
But beyond that, the example of Mr. Odinga you mentioned is actually, again, experience I also had when I was the president of the court, where I met some African leaders. And one thing Madam Bensouda did effectively in a systematic way was whenever there was an election, she had a way of reminding people, look, ICC is here. And that actually resonated because a lot of them told me, hang on, that they were telling one another, be careful with how we do this campaigning because we don't want to end up at the ICC. I thought I should point that out. It wasn't just Raila Odinga. I think it was something that resonated, and it is an achievement. Now, finally, on the point about deterrence and all that, I agree with Judge Ozaki when she said that the primary goal of the ICC ought to be whether we call it deterrence or prevention, as long as that means that there should not be any conception of the ICC's mandate that will give people the impression of impunity on their part. I don't want to give another slideshow on immunity here, but you know what I mean. Because if the idea, what I want us to avoid is the reading of ICC's mandate to mean, well, if we see international crimes being committed somewhere, maybe ICC has failed. That is not correct. It's not an accurate assessment of the mandate of the ICC because we don't make that assessment of any national criminal justice system. They say if there's a murder somewhere, it means the justice system has failed. And ICC is in even a weaker position to impose its own mandate or make it work than national systems are. So I thought it's important to stress that point, and thank you very much.
Thank you. Any comments from the panel in response to those 2 points, or shall we continue?
Just one point on Chief Taku's question about complementarity and why is that there is insufficient domestication by state party. So I think that to answer adequately this question, I think almost every state has its own story, so to speak. I can only relate to those states, including mine, which I know that, for example, Senegal took particular pride in being the first country to, ratify, but still it took us quite a long time to domesticate, and even then, I think that we still have some gap in our domestic system. But I think that this is due to many factors, including, and this I'm talking about from my experience as a UNODC regional representative, because part of my mandate at the time was to help state of the SADC region really to strengthen the legal framework. Sometimes it has a lot to do with even legislative capacity and many others issues like that. So I think that sometimes also reaching out and really assessing the capacity of those states, I think that could be something to help them really be fully compliant.
Question, please, from Professor Stone. Oh, you want to? Oh, please, go ahead.
With regard to the initial question, I think it's a very interesting point. And, well, as said, there are many multilateral convention scheme which has some kind of oversight mechanism. And it's a pity that ASP doesn't have this. But what ASP has oversight is citing is ICC as a judicial organization. And it's a pity that the Genocide Convention doesn't have that kind of oversight mechanism. Or maybe if we are to have this new convention against the crimes against humanity, maybe that could have that kind of oversight mechanism by state parties, like what we have in case of corruption convention or organized crime convention. So that's my answer to the reaction to the first question. And the second question from Chile about this mandate vis-a-vis this mandate issue, relationship between goal and mandate. Well, I agree with you, and that's exactly why I put so much stress on ICC as a judicial organization. ICC is not, for example, political or aid organization, but it's a judicial organization. And its ICC is a court, and that's it. So if we are talking about the mandate of ICC, we should concentrate on ICC's mandate as a court.
Professor Simmons?
Well, I'll just say, once we understood one another, I agree with you completely that nobody would ever argue that a domestic justice system doesn't need courts and law simply because there's still crime. And yet we do hear that echoed all the time in the international context. And yeah, we just got to really find ways to push back against that misconception at every opportunity.
Thank you. I'll give the floor to Professor Stan for another question. Thank you.
Thank you very much for an excellent and important panel. I think you've made the important point that punishment plays a certain role in relation to deterrence, but if we think about international criminal justice, we see that the deterrent effect is caused by many other factors than punishment. I would say punishment must be least of the rationales actually explaining it. And so this leads to my question, how could the ICC use its communicative power as effectively as possible in order to have that broader social deterrent effect that you've been speaking about, Professor Simmons? We hear the counter-evidence that obviously the initiation of ICC proceedings as such, it can have a deterrent effect, but it can also have an empowering effect on non-state actors who see that as incentive, as recognition of their own importance. It might actually then also increase violence. So how can we curtail that these effects emerge? So that's my first question. My second question goes again to what is specific about international criminal justice. Again, in domestic systems, we would say it's a predictability argument, which convinces us and which produces the deterrent effect. My question is, in international criminal justice, is it maybe not the unpredictability of conduct that might precisely serve also as a factor increasing deterrence, the fact that we don't know how an institution will act, whether it leaves an investigation open or not, whether it closes the P or not. So is it not also that unpredictability that contributes to deterrence in a certain way? Thank you.
And before you answer, can we take another audience member's question quickly? And can you identify yourself before you give your question? Thank you.
Sure. My name is Anush Bagdasarian. I recently graduated from Harvard Law School, and I'm a current visiting professional at the ICC. And I have a question. First, I want to say to thank you to everyone on the panel. And Professor Simmons, I particularly have found your work to be very foundational. And we read your 2016 piece about how can the ICC deter atrocity in my global governance class at Harvard, and it was impactful and persuasive. And so my question is for you or any of the panelists is the following, and I think it might be related to the last question. So Given that the consensus in the field of criminology is that crime is more deterred by certainty than severity, or by the likelihood of accountability, rather than by the severity of the punishment, how can we increase the deterrence effect of the ICC, particularly for those states that are not or think they are not within the court's reach? Maybe the creative cases by the OTP at the ICC with Bangladesh and Myanmar, for example, can keep countries on their toes, conferring jurisdiction on crimes that may have been thought to be unreachable. But do we increase this impression of certainty or likelihood of punishment and thus deterrence by greater ratification? Or do you think there is some other method, particularly for atrocities that may not fall within the court's jurisdiction? Or can we just not expect the ICC to reach or deter those atrocities? Thank you.
I think we have a separate panel exactly on this, whose outreach and to whom, which will be tomorrow afternoon session, panel 5. Yes, I think it's very, very difficult part. And ICC is not, I'm not sure whether ICC has done a great job in this respect so far. ICC is, of course, trying very hard. But honestly speaking, I'm not the PR specialist, and I have no answer. The only thing I can say is that here again, we need some kind of horizontal complementarity, and we really need help from other organizations which are better in better situation for outreaching and communication. That's what I can say. And with regard to the second question about the difference between domestic criminal justice and international criminal justice, I believe that in ideal world, there is no difference. And I'm attracted to the idea that the ICC has deterrent effect by unpredictability rather than predictability. I'm attracted to that idea, but that I don't think we should accept. We aim at the more prediction in that sense. And here again, we have to rely on this complementarity, because in ideal world, with this international criminal justice system, including domestic court, regional court, specialized court, or whatever, there should be predictability. So the goal is predictability rather than unpredictability. And this also relates to the issue of certainty and severity, and which I mentioned as the shortcomings of the ICC process. Again, it is only through complementarity and work together with the domestic court and other court, including maybe the court in the third country, that we can have this certainty and severity, I'm not so sure, but certainty and predictability as well. And of course, it's very difficult to reach the necessary level of certainty, but you know, it's we have to make every effort for that goal.
Okay, one quick point on ICC communicative power. I think that there may be many layers to that. One I just wanted to briefly mention, because it is still under review, is the statement, for example, the prosecutor make in respect of delicate situation where we may be moving towards something that leading to mass atrocities. What is the extent? For example, should we do that in respect of situation or potential situation where at least a jurisdiction can be established, or should it be a general policy whereby the OTP can make a statement irrespective even of those considerations? That's something prosecutor Khan is reviewing again. With respect to now what could be done to increase the deterrence of the deterrent power, so to speak, of ICC. Here again, I think that there are so many factors to be taken into account, but one, obviously, that I can also talk about and relay is the problem of resources of the court. Because when you look at the number of situations where, particularly even the office of the prosecutor could do much more had we had the adequate resources. So, but of course for that it's more of the member states now to see how much they can increase the resources of the court to be able to do more.
How to communicate. I think I'm going to speak in broad generalities here because I don't know the exact communication programs that are in train. But my recommendation would be, as much as possible, to stress common values early and often. Social deterrence depends on this sense that we all value these things, don't we? And I think, cultivating that has got to be an early and often thing that the ICC participates in. You don't want a people's first interaction with the ICC to be, we're coming after you. That's not where you begin on these things in a persuasive way, it seems to me. The other thing I guess I would, of course, there's a lot of things here you got to be careful about that I don't think the ICC is doing necessarily, but sort of creating kind of broader culture-wide or country-wide blaming framings. I think that's to be avoided. That's just general from the human rights area, essentially. That does not relate specifically to the International Criminal Court. I think at the end of the day that we need to remember that not everybody is deterrable. They're just not everybody is deterrable, but some groups are, and we need to nurture that. So, for example, in the Colombian case, one thing that I think was very important to the reduction in violence and eventually the peace process there was that the FARC was eventually was quite interested in being part of the legislature and being represented in government. They wanted to be brought in, and so they were very susceptible to social deterrence, if you will, because they wanted to be a part. Now, I guess the broader point then is that the ICC needs to be an institution with which people want to be associated, with which states want to be associated. How do we cultivate that is kind of the meta question, I think, around this issue of how to deal with the problem of communication.
Okay, thank you very much. We actually have a few extra minutes until we formally close a panel at 5:10. So one last question from the audience, and I will offer a few remarks to wrap up and then hand it back to Judge Goldstone to close the panel. Go ahead.
Thank you very much. Just one thought that came to me that maybe I would like to throw at the panel or at everybody as a little food for thought. Talking about communication, of how the ICC through communication could be deterrent, I was just thinking, how about victim participation? Those that are victimized today might be the ones that want to take revenge tomorrow. They might be the ones that are influenced by leaders to take up weapons. We've seen that at so many occasions throughout history. Victim participation at the ICC is the attempt to make all those that actually have been victimized by crimes in the jurisdiction of the court to be part of that process. The big machinery of victim participation, and the aim is that these individuals understand what the ICC is and feel that they are partaking in that process, in that justice process. Now, if one were to try to measure to what extent that has actually an effect of these individuals saying, I feel repaired through the justice that I may have partaken in, or at least seen taken its course, if that is not already a deterrent effect, focusing now on those that are the perpetrators potentially on the ground, not just always those at the very top level. So maybe that the deterrent effect comes from that perspective, giving obviously a beautiful new area of legitimacy to this entire aspect of victim participation. Just food for thought. Thank you.
Any brief response to that before we, would you, please? Yes, Prosecutor Bensouda.
I just want to say one or two things. And this is, firstly, I'm working on this poll, to widening the, so that we have more agreement. So I just, Professor Simmons, so I just wanted to add that when it's very difficult to gather this empirical data about what, the court has been able to prevent and what it hasn't. But I remember after the Lubanga case, I remember, and I used to talk about this, Radhika Kumwaraswamy, who was then the SRSG for Children and Armed Conflict, said she used the Lubanga case a lot. And she was able to get Nepal, which was a non-state party, to demobilize over 3,000 children who were already in the ranks. I mean, this is at least something very, and I have had similar stories like that being given to me by actually a member of parliament. I remember we met at a conference and he was talking about, even in the DRC, that the Lubanga case has also helped a lot to talk to militia leaders and to be able to demobilize children. So that is something that I thought would probably add to the impact that the ICC has had. But with respect to the statements, deterrent effect and the statements that I used to make, I just wanted to clarify that there has never been a case where I spoke at a situation where we did not have jurisdiction. Never. It was always, it's either on the preliminary examination already, or there is an investigation into the situation, or it is a state party to the Rome Statute. And because I was doing that, I was even being solicited by non-state parties, asking me to make a statement before elections, and I would say, no, I don't have jurisdiction to say anything. So I think that also is kind of an impact that you can be shown that it really had some effect. Yeah.
May I react? Well, with regard to gender crime and child soldiers, I think those are the crimes that ICC was more or less successfully in comparison with other types of crimes, more or less succeeded in awareness raising. But that is a kind of example of the success with cooperation with other organizations, like human rights organizations, women's organizations. And that comes back to what I said, that with regard to this outreach, with regard to outreach, it is really, and communication, it is very difficult for ICC alone to do that, and we really need a good partnership.
Any further comment from the panel? Or I can wrap up as well.
Well, I'll just say very quickly, Madam Prosecutor, thank you for bringing that up. That is the paragraphs I had to skip because I was in the red time, but it was definitely about, there's a study in York Law Review that comes to that exact conclusion about child soldiers in the DRC, is that how important those prosecutions and convictions were. For people to understand, that this is kind of like a serious issue, not just a couple of younger soldiers around, that it's a serious issue. So, I couldn't agree with you more based on what I've been able to read as well. So thank you for bringing that up.
Just also to express my agreement with Philip, what you said, because as I indicated, there are many layers to deterrence. But definitely, as you indicated, I think that, the victim's perspective as well could be extremely important to take also into account. And yes, Fatu, so I have taken note, that perimeter you define. I think that it's quite right. I think that sometimes that issue came up in a delicate way, even in this so-called country situation, where the situation also has evolved. One can say whether it is still the situation or not, just like, yeah, absolutely, yeah. Okay. But anyway, I take full knowledge of what you have indicated. Just to thank you that I agree totally with you. Thank you.
Well, thank you very much. This has really been a wonderful discussion. Just to close quickly, what Professor Simmons had said about traffic, red lights, it brought to mind one of the most deterrent impacts you can have, which is red light cameras, because they're certain and they're impartial. So I think in terms of the perspective from the domestic criminal law, the idea of certainty of punishment and the perception of that certainty, of course, is a factor which we're all aware of. But it has been written about that the existence of the court, as it has been described earlier, as still an achievement in itself, changes the calculus at least a little. There was no possibility when there was no court, and now there is some, and that is a hard calculation for people to make, but they do start to think about it. And as Deputy Prosecutor Niang was saying, complementarity can expand the chances of prosecution, can increase certainty, and therefore may increase the deterrent effect. And if I may maybe put my thumb on the scale a little in the interests of the Academy, we do have a book on deterrence, which came out in 2017, looking at 10 situations, 6 of them ICC, and finding, in fact, some deterrent impact in every situation. But in fact, it's not fixed. And like any impact of the court, it can be affected over time by the reaction of national actors who may decide I could change my behavior, or I could push away the impact or push away the force from the ICC or from other external impacts. So maybe it goes to the question of what is effective deterrence, but a similar question raised by our audience was, how do you determine when there's an end to impunity? And I think it verges into the philosophical at some point. But with that, I would like to hand back to Judge Goldstone to close the panel, and then I'll say a couple last words before we finish the day. Judge Goldstone?
Well, thank you again, Jennifer. It remains for me to add my thanks and gratitude to our excellent panel and for the very good questions that were put to them. Jennifer, thanks to you and everybody involved at the Nuremberg Principles Academy for making my participation possible, and for a wonderful day and a half. And I look forward very much to being with you, at least remotely, tomorrow. Thank you very much.
Judge Goldstone? Thank you, Judge Goldstone and the panel, for that fascinating discussion. And let's return briefly to Slido and see if we manage to have some impact on the outcome. May we have, please, the motion? 77 disagree, but 23% agree. So I think that is some progress. That is some progress. With that, I conclude our last panel of the day, and I look forward to joining you all, or those of you who are joining for dinner this evening, and to continue our informal exchanges then. See you tomorrow morning at 10 a.m. for the last day of the conference. Thank you, everybody.